Good afternoon. It's our pleasure to be back before you again for the Cook County Bar Association, our weekly program. And while we're off camera, our celebrated guest, Mika, well, I mispronounce her name all wrong all the time, but she rebuked me off the air and said if I mispronounced it, she was going to go upside my bald head while we're on TV. So we just hope that we don't mess up. But in any event, we were chatting. The Cook County Bar Association is actually 102 years old.
Yes.
And we had an installation banquet last Friday.
Yes.
And it was sold out.
It sold out. It was
Hyatt.
Wonderful.
And we had the incoming state's attorney, Ms. Fox.
Ms. Fox.
Okay. Honorable President Tony Pretwinkle gave remarks. The Honorable Tim Evans gave remarks.
Yes.
The presiding judge gave remarks. So we just had a plate full of information.
We did.
And folks just enjoyed themselves, and the reception was nice, so forth and so on. It was a live band.
Yes.
And ladies and gentlemen, your Cook County Bar Association is next level.
Yes, it is.
Okay,
yes,
we try to bring information that you can use on a daily basis. And your bar association, every once in a while, likes to stretch out like we did last Friday. There's nothing wrong with that.
Yes.
In terms of that is our main fundraiser.
Right.
And it was actually sold out at the Hyatt Regency.
Yes.
And we just had a marvelous time.
We have been working hard this year to also affect change in the state legislature. We had one of our members, Jared Williams, on a previous show, talk about a lot of those changes. So that Friday's banquet was well deserved and well enjoyed. I enjoyed myself.
Absolutely.
It was very nice.
Live band, so forth and so on. Well, ladies and gentlemen, we encourage you to call in. If you don't, Mika and myself, we'll just keep on talking. But it'll be more fun if you interact with us. And that number is 312-738-1060. Let me repeat that, 312-738-1060. Today's topic is going to be divorce.
Yes, yes.
Now, unfortunately, not be funny, but a lot of people get divorced.
Yes,
okay.
they do.
And with divorce, there comes some side issues. The side issues are custody.
Yes.
Is that right?
Right.
Dealing with the division of property, so forth and so on.
Right.
And this is your chance to get some free information.
Right.
And let me tell you this, the divorce is not my area. Okay. However, it's an area that is ongoing, and is the area that really, in Mecca, as we get into the program, I'd like for you to address how is to both parties' benefit to try to come to a resolution.
It's very much to both parties' benefit to come to a resolution, specifically because in the state of Illinois, the law pertaining to divorces has changed. As of January 1st, 2016, the Illinois Marriage and Marriage Dissolution Act was completely revised. And a lot of the definitions regarding divorce, the terms like custody and visitation no longer exist. The way in which the grounds and bases have completely changed, and the manner, the process has changed. And so the courts are now going to basically kind of start from scratch in certain areas of marriage and dissolution, and the attorney's ability to really predict how this new statute is going to be interpreted is sketchy now until we get some more case law and these different challenges are made to particular provisions of the law are appealed to the appellate level and reviewed by the state Supreme Court. We are not in the best position to give you just a definite answer as to how different provisions will be interpreted. So it is to both parties' benefit to interpret how they want their divorce to go themselves.
Well, counsel, let me ask you this. Now, you speak to me as if I'm a layman, because actually, we have a caller.
Okay.
Caller, are you there? Caller.
Second, let me turn my TV down. Yeah, I do. Thanks for taking my call. I have one question about divorce and all the changes that have happened. I mean, the definition of marriage has been changed recently. Now the definition of divorce is being changed recently. I was divorced or married under a different definition of marriage, and then divorced now apparently under a different definition of divorce. So when it comes time where the whole mess has played its course, under which definition will my current dissolution agreement fall? Is it under the new one, or is it under the old stuff?
Okay, now are you a heterosexual couple, or was a divorce with regards to a homosexual couple? Because that's relevant.
We were heterosexual.
Okay, so the definition of marriage.
Now my former partner is now involved in something more homosexual. So I mean, there's all sorts of weird things.
Oh wow! Okay, you are in a very different. Okay, so the law. How long ago was your divorce final?
Oh, close to 10 years ago.
You would be under the old law. Your marriage and the provisions of your marital agreement would be under the old law, unless you and your partner agree to be, the terms to be interpreted under the new one. So no, it would be, that's too long. The old law would govern your divorce, and as far as
Thanks.
okay, and as far as
I ask this one last bit here.
Okay.
Before it's if that is the case, then the old laws still govern. There have been a couple of adjustments and things since then. Basically, dealing with our joint parenting agreement and all that stuff. And to think that I might have some static on the back end is a little unsettling. So you're telling me that there's this possibility that I'd be adjudicated under the old one as we're reaching the end of our agreements here, but what's the likelihood that I might have some static from the state or another body that is just a state, but for the things that have happened up until now?
Well, I'm not understanding. If you have a marital settlement agreement, it should be in the terms of that agreement. It should be applied. The old law should apply to your agreement. Now, as far in the parenting plan and so forth and so on, because that's according to you enter. That's a long time to to try to now apply, because now, and I preface this with the fact that this law, as I stated in the introduction, has to be interpreted by the appellate level courts. And according to the research that I looked at, it was the Illinois Family, and there's a agency that conducted a study. The Illinois Family and Health Committee, they did the study that formulated, and that was a study that was done in 2008, that formulated the basis upon which they made the changes that are now effective in 2016. And what they said was that the society has changed since the act was originally enacted in 79. We are now in 2016, and because the society has changed, our attitudes about family have changed, our definition of the roles that mothers and fathers and mothers and fathers, how they define their roles in a family, quote unquote, has changed. And so to that extent, there needs to be changes in the law. Your marriage and your divorce happened 10 years ago. So you weren't part of the new changes. You were, your marriage and the divorce occurred under the old definitions of family and so forth and so on. So an argument would be made that it wouldn't be fair to impose this new standard based on new family structure to your divorce, is what I'm saying. But I recognize, and I am not disputing your concern. Your concern is that there's still a risk that some case law may come down from appellate court or the Supreme Court that may allow an argument to be made in your case, in cases like yours, that the parenting plan or any modifications that you're seeking to have now be interpreted according to the new law. I recognize what you're saying,
Right.
and that is a risk. I'm not saying that that's not a risk, but what I am saying is I think your argument is strong, where you could say the basis upon which that statute was entered does not apply to me. You understand? In our marriage.
Great. Yes, I do. And
Right.
it's a wonderful way to explain it. Thank you so much. Have a
You're
great
welcome.
time.
You're welcome.
Bye now.
Okay, we're gonna break it down. How you said the society changes really drove this legislation or this change.
Right.
What society changes are you making reference to?
Okay. Again, according to this study, and this study was done in 2008, and they were trying to figure out, we've got, for example, the technology is a big change. Now you can look and get that DNA versus the blood test and know definitively that this child isn't your child. And there have been a number of cases where across the United States where men have found out years later that they thought they were the father and they're not the father. So you got situations like that, and they're signing birth certificates, thinking that this is their child, and then the real father shows up and they want to stuff like that type of thing. And
let me ask you this.
Okay.
In terms of DNA, now that the DNA is more prevalent, is that the right word? In terms of DNA testing, are you saying under new changes that have come about, would it be more easier? Is that grammatically correct? Excuse me. Would it be easier for someone to challenge? Say, for example, they would determine the father years ago. Okay, years ago under the old system. If they came with using the new system in terms of DNA testing, are you saying that opens the door for someone to challenge the paternity?
Yes, it does, because at that time, that voluntary acknowledgement of paternity did not recognize that there was this possibility that DNA would rule them as, and they weren't giving consent. So when you're saying I acknowledge paternity, you couldn't say back then, when it was just a blood test, that I'm acknowledging that I am the child of this father, when I couldn't get a DNA test. You see, and it was just a blood test. And now that they can test for that DNA, you can have a more definitive answer. How would you know? You know what I'm saying? When that really, that certainty that the DNA brings to the table wasn't available. So how can you acknowledge, paternity when that type of paternity, that test wasn't really available to you to do it? So let's say the blood test was done and it said one thing and DNA said something else.
So again, is this opening the door for
it
people
has, it really has.
to come back, to circle back,
and as a
challenge
consequence,
something?
that voluntary acknowledgement of paternity has changed. The language in there has changed to accommodate that reality that a DNA could determine that you are the father. So when you sign a voluntary acknowledgement of paternity today, you are waiving your right to challenge on the basis of DNA.
Okay, it's waived.
It's waived now. But whereas before, that language wasn't even in the, years ago. It wasn't in the voluntary acknowledgement. Now it's in there.
So you're saying before it was not possible to waive your rights to challenge it once you acknowledge being a parent?
Right. Back then you couldn't. We have a caller?
No, I think we're okay.
Okay. You couldn't challenge it before DNA existed, because before DNA
Yes,
existed.
we do. Thank you. Good catch. Call, are you there? Call, your question, please.
Yeah, my question is, I have a cousin who was he was fighting a case at 26 in California, and there was a judge who was on the bench. My cousin was fighting the case since January 1st, 2012. Well, the thing is, the judge that was sitting on the bench, she was gone for approximately 9 months.
Wow.
And, come to find out that this judge was battling cancer. And upon this, I did a little research on this judge, and this judge had, she had numerous overturned convictions. She she held people contempt of court and everything, but her overturned convictions were all overturned by higher judges. Meanwhile, what I'm saying is this lady still have her job. There's no fairness in front of her, and I'm trying to find out why is it that she's still on the bench, and she's clearly unfit for the job.
Now you're talking about criminal, right? This is in a criminal case. Okay, we're talking about family law, but you
right. You know, we have very limited time.
I understand you're talking about family law, but since we're talking law, this is a very major subject.
But sir, I don't want to cut you off, and I don't want to be rude. Today's topic is divorce, and we have precious little time to deal with that topic. Your topic is an entirely different topic in terms of whether someone deserves to be on the bench or not. That's an entirely different topic. So please, we'll be back on next week, and maybe in the future. This is the last show, but we will be back, in the near future.
And you're free to contact the Cook County Bar Association and ask for the lawyer referral, and they will refer you to a criminal attorney that can answer your questions.
Okay, thank you. Okay. Now we got a little time. This is critical.
Okay.
I can see a lot of people challenging stuff.
Well, again, what my understanding in talking with some of the different attorneys in my field, as well as those that work in the Children and Family Services, that the numbers of people signing off on the birth certificates have reduced as a consequence, because they want to make sure that they can challenge it on DNA grounds. And if they sign that you can't sign the birth certificate now without signing a voluntary acknowledgement of paternity. And again, that wasn't always the case. You could do either or. Now you have to sign if you're going to sign the birth certificate, you have to sign the voluntary acknowledgement of paternity. And so if you sign that, then you waive it. And that you could sign the birth certificate without signing the voluntary acknowledgement of paternity. But if you sign the VAP, voluntary acknowledgement of paternity, you waive the right to challenge it on DNA grounds. So it may not.
I don't know, I don't know whether that's good or bad.
Right.
Because this is open the door for a whole lot of conversation. Because, I can see some folks being reluctant to sign off. There's some down in mind, which could throw some havoc into the family structure, for a whole lot of reasons. Well, in terms of the grounds for divorce, what are the grounds for divorce, and have they changed under the new act?
The grounds for divorce now are irreconcilable differences. We used to have 3 what they call heart-bomb statute basis grounds for divorce, and that was alienation of affection, breach of promise, and criminal conversion. The alienation of affection would allow you to sue the mistress or the mister, the person that was having a relationship with your spouse, and you could sue for damages.
Is that under the new law or the old law?
Under the old law. And then they had the criminal conversion, which would allow you to sue the spouse with regards to the lawsuit arose because of the sexual interaction between your spouse and some other party. The breach of promise was one that you could sue for damages resulting from the breakup of the engagement. So you spent money on a wedding, the engagement party, and so forth and so on, and you could sue for that. Those are no longer available in Illinois as a result of the new law. And then you had a number of grounds that were called the fault basis grounds. That was adultery, impotence, bigamy. And bigamy was where your spouse was married to you and somebody else. Abandonment of the marriage for at least a year, alcohol abuse or addiction for 2 years, attempting to take the life of your spouse, extreme and repeated physical and mental cruelty, a felony conviction, and the your use you were infected with a sexually transmitted disease by your spouse. That was another grounds for divorce.
So all that is gone.
That's gone, and we're left with the irreconcilable differences.
Well, let me ask you this, again, layman terms, because I didn't realize, because again, this is not my area.
Right.
I did not realize that you could sue somebody for interfering in your marriage.
Yes,
that's basically
in
what
Illinois.
you're saying.
Right. Yes,
okay.
you could. You
okay.
could. The judges tended, I mean, since I've been practicing about 12 years now, and the judges tend to frown on it. They haven't liked it. So if you bring the case, it's expensive because they really make it difficult for you to prosecute that case. But it was available. It's on the books, and you'd have to go through it. It's not a cheap case, but at least, especially with the breach of promise, you could get your money, your litigation fees, as well as damages for saying that you're going to get married to somebody and they spend all this money on wedding and so forth, and it doesn't happen. So
it's now just irreconcilable differences.
It's irreconcilable differences from divorce. Now, that does not mean that you can't do something maybe in chancery or toward civil, in the civil law divisions. I don't know. I know for as far as under the Illinois Marriage and Dissolution Act, under the divorce division of domestic relations divisions of the court here in Illinois, you can't file those. They call them the heart bomb actions. So those actions are no longer there.
What about property in terms of this, fighting over property?
Okay,
has that changed?
Yes, there has been some changes, and they tend to be more procedural with regards to changes with regards to property. So the assets, for example, when you're asking for a division of the assets, there needs to be specific findings of fact that the court makes and uses as a basis for the division of those assets. The court can now appoint and force you to pay for a financial expert that they select. Prior to this, the divorcing parties could hire their own financial expert. You go to trial. You put put them on the stand, and you ask them to give testimony regarding their opinion of how the property should be divided, the marital assets should be divided, and then the judge makes a decision based on that. Now the judge can say, I don't have to listen to those people. I mean, you can put them on, but I don't have to listen to them. I'm going to say that this person from this firm needs to come in and give me, look at, you need to open up your books to that person and and both parties, and that person will give me an independent, quote unquote, independent opinion, and I'll make a decision based on what that person says, and that can be expensive.
Well, counsel, this is your area, not mine. But I want you can't, if you have an opinion, is it better this way in terms of the evaluation process that the judges are using for property disputes? Is it better, or in terms of the litigants and giving them more of a fair chance?
It's expensive. That's what it is. It for many, since the Chicago, Illinois is going through this budget crisis. We all know that, and the citizens are taking it even harder. I mean, when the state doesn't pass a budget, teachers don't get paid, civil service don't get paid. So that means their income is less, or it's the amount of money you're willing to spend on different things you're not willing to, because you don't know what tomorrow is going to bring. So divorcing and having to then pay the attorney, and then possibly pay your spouse's attorney when it's all over, and then have to pay a financial expert. And if you have kids, the court can also appoint a GLA, a guardian ad litem, to come in and evaluate the kids, your house, and then your spouse's house. And that person you have to pay, the parties have to pay for that person's time. So that's a lot of people to pay, and it's expensive. So I don't know. I mean, dollars and cents, no, it's not better.
Okay. We've only got about a minute to go. You have the final say-so.
If you're considering divorce in the state of Illinois, I strongly suggest that you and that other person really sit down, put as much of the personal issues aside and really come out with some sort of agreement that you can live with before you retain the attorneys. If you guys can come up with some idea of how you want to separate, how you want to parent your children, you will come out way cheaper, and you will have an agreement that will stand the test of time, so that you're not constantly having to go back to a third-party judge, a financial expert, a guardian ad litem to make a decision that you and that other person can make on your own behalf. Normally what happens is in the divorce that people burn out, and then they end up coming back to this point where they're working with that other person. So since that's going to be the end result anyway, you might as well start from that point and keep the money in your pocket.
Very good. We've enjoyed ourselves. Look to see us in the near future. I'm not quite sure when we'll be back on the air, but when we will, we'll be doing the best we can to give you information that you can use. God bless you.